Good morning, namaskar, sat sri akal. And this is in continuation now with the House Accommodation Act 1902 1923. Now, this is in the J.P. Mittal book 1986 edition. Now, what does it say? What does status quo explain the meaning of these sections? Section 10C or Section 13, as this may be, cannot be contravened as my predecessor had already by private negotiated treaty placed my tenement on the government of India lease under the C.G.B.L or whatever tenement they may be, other than my self occupation posed reposed in the bungalow are already reserved for enacted purposes. You cannot assign it forcibly or otherwise duplicate the constituted purpose all over again. Now, what is the purpose of this military accommodation, which clearly reads it cannot be duplicated as the bylaw is already active in force by the C.G.B.L called the Central Govt Bye Law as per Section 13 of the House Accommodation Act written on page 802 of J.P. Mittal. Now, what is status quo and why we should be seeking status quo? Now, the Central Govt Bye Law is reservation for meeting house accommodation purpose when directed. However, any other purpose must be terminated on demand from the army or in case authorities finds unauthorized occupation by violating that bylaw, which is in Ambala bylaw number 40. A notice can be served on the owner to get the tenement vacated. Let's say if the bungalow is not in my possession as an owner, but in possession of a tenement, and the military wants my bungalow, falling within the Cantonment House Accommodation Act, under this bylaw or this notification, the tenement or the tenant of the owner needs to be vacated. Now, friends, we will need to understand this law in a more clearer manner, that historically, how did this law finally take its shape? There must have been some precedents on it in the past during the British regime. Now, what are those precedents? So, let's try and understand those. Now, I will read from Cant Manual, Appendix 19, the Journal Order by the Governor General in Council dated 25th September 1807. The Carroll's Code, Section 11 under 107, clearly says sale of building after valuation ordered that on occasion of the disposal of premises and dwellings which have been occupied by staff officers within the limits of any military cantonment so situated as to render them in a peculiar manner adopted for the residence or due discharge of the official duties of officers succeeding to such staff situation, the vendor of such premises and dwellings shall be bound to dispose of, and the successor to such appointment to purchase them at a fair valuation by the committee of an arbitration constituted. Now, house not to be sold or occupied by civilian. Now, what does section 1110 say? That no bungalows or quarters at any of the cantonment shall be allowed to be sold or to be occupied by any person who does not belong to the army. Then how come we are there? Similarly, house not to be sold or occupied, section 111. If individual, not officer, shall purchase, they must remove the and appropriate it exclusively to the use of the troop. That means We must remove our building if it's going to be appropriated or resumed. Now, let's read the other resolution of Military Board dated 29th March 1808. House reserved for army officer. So, meaning before even 100 years, 1902, the House Accommodation Act came. 1808, the regulation imposes no restriction whatever in respect to the sale or renting of the quarters which are private properties beyond that of their being reserved for the officers and the staff of the army and lieutenant. So 1808, private properties were existing within the cantonments. The house claimable for purchase or hire at option of owner. All houses in a military cantonment being a property of person not belonging to the army, which may be deemed by the commanding officer of the station suitable from their locality for the accommodation of officers shall be claimable at purchase. So either we have to sell our bungalow and it has to be purchased, or it has to be rented. This is all what is happening. And a committee of arbitration is to be constituted as follows. The committee is to be composed of one civil officer, the principal one, if practicable, at or in the vicinity of the station, the commanding officer of the cantonment, and an officer belonging to the station to be named by the proprietor of the premises. Now we were owners, here we are proprietors of the premises. And this their decision whether relating to the terms of purchase or rent is to be conclusive, unless it shall be reversed by government, for whose order the proprietors of the committee is to be submitted through His Excellency, the Commander in Chief. Whenever the proprietor of the premises which they have valued is dissatisfied with their award, when the house of the officer of one corp ought to be transferred to those of another, as on the occasion of a relief, if a difference of opinion should arise as to the fair terms of transfer, the price shall be fixed by the committee of arbitration constituted as in the last para, but to which in such cases there is to be a given an additional member by the name by the intending purchaser. So two parts have been said. If the house is in the possession of an owner or a proprietor, it is to be purchased and a committee is formed. And let's presume if the house is going from one officer to the other officer, how it has to be. Permission to occupy confers no proprietary rights. Resumption of land committed committee of arbitration of these new grants. So once again, what is it? New grants. Governor General Order number 260, 7th May 1838 clearly says all GGOs in the preceding presidencies is rescinded. Now, this also similarly says permission to occupy ground in a military cantonment offers no proprietary rights on the occupant. It continues the property of the state and resumable at the pleasure of the government, but in all practicable to the state and resumable at the pleasure of the government. But in all practicable cases, 1 month notice of resumption will be given. So somewhat things were different. One was GGO 179, the other was GGO 260. Now boundaries, exclusion of private lands, where in regulation and orders of the Army Bombay Presidency 1875. It clearly reads limits of cantonments or bazaars shall be marked by the magistrate or political agent, and in conjunction with the commanding officer in making the limits of a new cantonment. Private property is not to be included there. So that means, are we trying to say in this that anything after the notification or after this order of 1875, if a cantonment boundaries have to be made, in that area there will be no private property, but prior there were. Wherever an alteration may be required in any part of the limits of the cantonment which have been regularly marked out and published, the magistrate and the commanding officers are to draw up and sign a report and plan of the entire limits as proposed after alteration. And a new description will then be published in journal order, which will be considered to supersede and cancel the previous plans and registers. Good enough. Another book, House Owners and Tenants, 1925. What does it write? Grants. In cases where a written instrument conveying the grant of a site is forthcoming, land is admitted by the owner to be government property, then it may be considered that the site is subject to the rules, and in such cases, the date of the original grant should first be ascertained. Good enough. Everything is written, friends. How to purchase, how to refuse, how admission deeds to be given, how leases were converted of these properties or grants or old grants. A proposed to buy a bungalow in a cantonment and applied for sanction of the local military authority to the proposed transfer. He was informed that sanction would be given if he agreed to sign a document making the house available on demand for occupation, agreed to condone this offense if A, in the first instance, failed to comply with this stipulation and purchased the house, always liable to appropriation of military officer, and A agreed to build a second liable to appropriation of a military officer, and A was requested to execute two leases in accordance with the provisions of the cantonment code for the site. This A, if declined to be and was threatened with the resumption of the site, he thereupon may appeal to the army headquarters. So, meaning by that the original builder from 1845 to the original bungalows, they always applied for sites, whether to be constructed or granted, ever since 1843 or maybe earlier. So sanctions were conveyed under the Governor General orders of various, maybe 179, 260, or 14. Now, why was House Accommodation Act made applicable? This is very important. So the was applied to that part of the cantonment in which this bungalow is situated, and way back in 1919. Which bungalows? Where are these bungalows? What is the list of house accommodation in your cantonment? All needs to be dug in. That the house in question is not liable to be appropriated till the government sanction letter to resume such grant or a written instrument within the meaning of section 4 of the act, which together with the application of the original builder read with the Governor General orders of 7th May 1838, constitutes a contract in writing, the conditions of which could not be altered except by an act of legislature. Ceding them, this was done while making the Act of 1902. So the notifications were very important. Bylaws were very important. We in Ambala have a bylaw 30. Eviction could not be done if your bungalow was within the Cantonment House Accommodation Act. So the present owner is governed by, in which case, by the original grant, and that the owner of such is not immune from eviction in favor of a military officer, which he would have been if were in occupation of the houses. So many things are written in this act. So many things are clubbed since 1808. Government has been, whether it was the British regime or later, well, after independence, our government was basically copying the facts which were moreover written by the Britishers. So anything new was not given up there. So what was everything? Now, the legal obligation on the part of the owner A to ask for sanction of government to the purchaser of the house, nor could the GOC veto or annul such purchase, and that so long as the authority do not seek to take possession of the bungalow or to resume the land under the said Governor General order, the house can transfer it to anyone. So where is that question in which Pune Ghaswala case was written that there was a permission given by the commander in chief? Remember, a permission is only given when the grant document speaks of it. When there is nothing forthcoming and you are subjected to an House Accommodation Act, then you never required any permission. But the fancy is going on. I have already explained you in my earlier video of House Accommodation Act. No notice can be issued under Section 14A under any condition, rules, and orders. It very clearly says it's given cut dates for Bengal, it's given cut dates for Bombay. So, what are we doing? Now, if we go to page 67 of the Cantonment Code, Appendix 19, where private lands have been defined in 14B, under any conditions, rules, regulations, or orders which were in force. Now, for Bombay, it says first June 1875. So, friends, everything was in place. I would use a simple word, this kind of a muddling or a galuara was purposely being enacted, but the Britishers were writing everything in black and white. But unfortunately, we had to read all this. I can imagine in 1911, nothing was being photocopied, nothing, documents could be given to anybody. So, how could Pune Ghaswala win his case? Even similar situation rose for Purushottam Das Tandon. And many of the advocates, specifically in Ambala, we have advocate Libran speaking that the minute we plead House Accommodation Act, we are gone. For what reason are we gone? Had it been not granted to owner, had it been not from purchaser to renting, there is no word being written in the act as resumed. So, what is the big deal of hiring your bungalow instead of resuming your bungalow? So, friends, once again, I'm saying, let us discuss this. Let us all sit together. Whoever is watching my video, take it to your advocate. Try and brief him. If you can't, let's have Zoom meetings. I am always there to educate people. Okay. So, that's my request. Thank you. Good day.